Hi friends, I am Professor N.S.Syama Prasad. In the last class we have discussed the formation of the Constitutional Assembly and the enactment of the Constitution of India. Now we shall discuss the major criticism against the Constitution of India and also the borrowed provisions. We have borrowed profusely from the Constitution of other countries. These things we shall discuss today. First of all, about the criticism levelled against the Indian Constitution. We have seen the Constitution was made mainly by lawyers, and about 80% of the members of the Constitution were lawyers, and they framed the Constitution using so many legal terms. And what happened was, there is a criticism that Indian Constitution is a lawyer's paradise. They argue that the Constitution was made by lawyers. They used so many legal terms in the Constitution and has made it a very complex one. That is why it is Ivergen is called this a lawyer's paradise, because lot of litigation will arise on the basis of this Constitution, because it can be interpreted in different ways. For example, you can see on a particular matter, High Court interprets the Constitution and gives a decision, and when you go and file an appeal in the Supreme Court interpreting the same provisions give a different decision. That means different decision can be there, different interpretation can be there, and the criticism is that the lawyers made a Constitution in such a way that they will get a lot of cases. Anyway, one of the major criticisms against the Constitution is that it is a lawyer's paradise. Second criticism is elephantine size. It is the biggest Constitution in the world. We have discussed in the earlier class that our Constitution is the biggest Constitution in the world, lengthiest one in the world, or the bulkiest one in the world. 395 articles and 8 schedules originally, and now 12 schedules. Actually, we have added a number of articles, 35, 40 articles have been added, but they are added as part of existing article. Therefore, total number in the Constitution remains at 395. But schedules have gone up. There are 12 schedules. It runs into about 250 pages. It is a big document. No other country has such a big constitution. American Constitution is hardly 4,000 words, and Indian Constitution 1.5 lakh words are there. It is a very, very big Constitution, because lot of details, all kinds of details are written down in the Constitution. That's why it has become a very big Constitution. And third feature is that there is a criticism that it is a Congress document. Why it is called a Congress document? Because at that time in the Assembly, most of the members belonged to the Congress party. Actually, Congress party at that time, Congress was not a political party at that time. It was Indian national movement itself. And people belonged to different political parties rallied under the Congress party because their aim was to gain independence. So Congress party functioned like an umbrella party, and all people having different ideologies, different policy program rallied under the Congress party. Therefore, the criticism is that it is a Congress document. That is not exactly correct. Then, next important criticism is that it was not subjected to referendum. Referendum means a law is referred to the people to know their opinion. That is called a referendum, referred to the people. When the Constitution of India was ready, some of the members of the Assembly, as well as some of the people outside, they demanded that the Constitution be referred to the people, because the members of the Assembly were not elected directly. Therefore, they wanted the Constitution to be referred to the people, so to know whether the people agree to a Constitution, whether the people ratify the Constitution. But Jawaharlal Nehru said it is not possible to hold referendum on Indian Constitution, because at that time we know about 60%, 70% of the people are illiterate, and no point in asking them whether Constitution is good or bad. Therefore, Nehru said no question of referendum. But he made an alternative suggestion. Most of the members of the Congress party, most of the members of the Assembly will be contesting elections. Elections are to be held to the Parliament and Legislative Assemblies within a short time. They will be all contesting. Suppose if they are all elected, that would mean the people have accepted a Constitution, they have ratified the Constitution. But suppose they are defeated, that would mean that the people have not accepted the Constitution. Anyway, after the election we have seen, most of them were elected. Congress party members were elected, Nehru was elected, most of the members of the Assembly were elected. That was indirect ratification in a referendum, and the people have ratified the Constitution. So that was another criticism. Then another important criticism that we have to study in detail is, it is a borrowed constitution. Indian constitution is a borrowed constitution. And we have to study what are the provisions we have borrowed from other countries. Because we have our constitution, we wanted to have very good provisions of other constitutions incorporated in our constitution. Therefore, we have taken the best provisions from the constitutions of other countries. For example, from Britain, from America, from South Africa, from France, from Russia, from Japan, from Canada, from Australia, from all these countries, we have taken important provisions. Our idea was to make our constitution a perfect constitution. But now constitution is perfect, and Indian constitution is not exception to this general rule. But you must always remember the fact that India was ruled by the Britain, by Government of India Act of 1935. And this act continued till 1950 until India became a republic. And Indian constitution is actually a revised version of Government of India Act of 1935. And the criticism that is that it is a carbon copy of Government of India Act of 1935. And you know, some days a question may be asked, which is the main source of Indian constitution? You are given an option like this: Government of India Act of 1935, British Constitution, American Constitution, Canadian Constitution. The right answer is the Government of India Act of 1935. See, a person buys an old building. He buys an old building and he renovates it, adding a lot of new facilities, new things in the house. That becomes a new one. Similarly, the Government of India Act can be compared to an old house, and we changed this. We renovated them using lot of provisions from other constitutions. Like, for example, the old house is to be well maintained. We added AC, we added curtains, we added lights. Similarly, the Government of India Act was amended. We added a lot of provisions, and our idea is to have a perfect constitution. Anyway, the criticism that it is borrowed is not correct, because the constitutions, provisions, fundamental rights, directive principles have no proprietary rights. It is not, there is no patent right. Therefore, any country can adopt this. It does not belong to any particular country. Now we shall discuss the various provisions we have taken from the constitution of other countries. First of all, we shall discuss Britain. What are the provisions we have taken from Britain? As we all know, we are under British control. Therefore, naturally we adopted the parliamentary system of Britain. Parliamentary system of Britain is adopted in India. But you know, America was under British control, but they adopted presidential system. We were under British control and we adopted the same parliamentary system. Our parliamentary system and British parliamentary system are almost similar. Only difference is that Britain has a king or a queen as head of the state, whereas India is a republic and it has president as the head of the state. Otherwise, both countries have a parliamentary system. And you know, Indian constitution nowhere says India has a parliamentary system. There is an article 75.3. Article 75.3. Article 75.3 says, Article 75.3 says, the Union Council of Ministers shall be collectively responsible to the Lok Sabha. Union Council of Ministers shall be collectively responsible to the Lok Sabha. From that statement, we come to the conclusion that India has a parliamentary system. Nowhere in the Indian constitution it is written that India has a parliamentary system. But you know, we have now developed a new theory called basic structure theory as a result of Kesavananda case. And in the basic structure theory, Supreme Court has said parliamentary system is a basic feature of Indian constitution. So, parliamentary system we have taken from Britain. Parliamentary system has another name. It is known as cabinet system of government. Sometimes it is called Westminster system. WESTMINSTR, Westminster system. And sometimes if the power or the Prime Minister enjoys vast powers, this system is called Prime Ministerial government. Anyway, we generally use the term parliamentary system that is adopted from Britain. Second important feature we have taken from we have important provision we have taken from Britain is the rule of law system. We have adopted rule of law system. Rule of law system means everyone is equal before law. Nobody is inferior, nobody is superior. As far as law is concerned, everyone is equal before law. So, a director of police commits an offence, chief secretary commits an offence, minister commits an offence, he will be arrested. Case will be taken against him. He can be punished in the ordinary court. No separate courts to try officials. No separate courts to try politicians. Everyone is equal before law. That system is called rule of law. From the Prime Minister down to the ordinary citizen, everyone is equal as per Indian Constitution. But there are some exceptions. 2 or 3 exceptions are there. I told you from Prime Minister downwards. See, President has some protection. Indian President is given some protection. Governors are given some protection. They will not come under the rule of law system. You can see, a minister can be arrested by the police. Chief Minister can be arrested with the police. We have seen recently, Chief Minister of Delhi was arrested and kept in jail. Deputy Chief Minister of Delhi was arrested and put in jail. The Chief Minister of Tamil Nadu was arrested and put in jail. So, Minister can be arrested, Chief Minister can be arrested, Union Ministers can be arrested. But there is a protection given to the President of India and the governors of states. Article 361. Article 361 says, the President of India cannot be arrested during his or her tenure. The governor cannot be arrested during his tenure. And similarly, no criminal case can be filed against the President or the governor during his or her tenure. For example, a person takes charge as a President. He kills somebody. Now, normally it would happen, but he kills somebody. He cannot be arrested. No case can be filed against him. You have to wait till 5-year period is over. Till he lingers office, he cannot be arrested. So that is a protection given to the President and governors. They cannot be arrested. No criminal case can be filed against him. They will not come under rule of law system. So that is an exception to the general rule of law system. So rule of law system is taken from Britain. Third provision we have taken from Britain is bicameralism. Bicameralism. Bicameralism means legislative body having 2 houses. So legislative body may have only 1 house, it may have 2 houses. If there is only 1 house, that is called a unicameral system, and if there are 2 houses, that is called a bicameral system. So our parliament is a bicameral one. There is Lok Sabha and there is another house called a Rajya Sabha. That we have adopted from Britain. British parliament is bicameral. There are 2 houses. One is House of Commons and the other is House of Lords. British parliament has 2 houses. American parliament has 2 houses. American parliament is called a Congress. One house is House of Representatives and the other is called a Senate. So most of the countries have bicameral legislatures. Very few countries have unicameral legislatures. China has a unicameral legislature. The parliament of China is called the National People's Congress, and the biggest legislative body in the world. There are about 3,000 members in the National People's Congress. So we have adopted the bicameral system for Britain. Not like that, in the British bicameral system, the lower house has more powers than the upper house. House of Commons is very powerful, House of Lords is very weak. Same system is followed in India. Lok Sabha has more powers than Rajya Sabha. But in America you can see the upper house Senate is very powerful, lower house is weak. So that may vary from state to state. Anyway, we have adopted bicameral system from Britain. Next we have taken first past the post system. That is a system of election. First past the post system. It is very simple. It only means among the voters in an election, among the candidates in an election, he who gets more votes than the other candidates will be elected. If you get more votes than the other candidate, you will be declared elected. No minimum is prescribed. For example, in a constituency, there are 100 voters and there are 5 candidates. A candidate gets 25 votes, second candidate gets 24, third candidate 22, then 21, etc. Then the candidate who got 25, he has got the highest number of votes, he will be declared elected. No minimum is prescribed. That system is called first past the post system. That is used in the election to Lok Sabha, election to the state legislative assemblies, and election to the panchayat bodies. In this election, we are using this system. There is another system that is called proportional representation. That is used in the election of president, in the election of vice president, Rajya Sabha, that we will discuss later. So this is also taken from Britain. Then another is the legislative procedure. The legislative procedure means how do we make laws? The laws are made by the legislative body, but the bills are introduced normally by the government ministers. So how a bill is prepared, how the bill is passed, that is known as legislative procedure. That is taken from Britain. And next, another important feature we have taken from Britain is the privileges of MPs. MPs have some privileges. You know, MPs have rights. Right to vote is a right. But along with that, they enjoy some privileges. They enjoy maximum freedom of speech and expression. For anything said by them in the parliament, no case can be filed. So privileges are given to the MPs. That is also taken from Britain. And finally, one more we may say, single citizenship. We have taken the idea of single citizenship from Britain. Britain consists of Wales, Scotland, Northern Ireland, etc. But there is only one citizenship. Similarly, in India, we have only one citizenship. Even though we have 28 states and 8 union territories. So these are the things we have taken from the Constitution of Britain. Anyway, we have to say generally the British Constitution is unwritten and they mainly follow customs and convention, but there are some provisions passed by the Parliament which form part of the British Constitution. So these are the things that you should remember taken from Britain. Often they ask the question, this provision is taken from which constitution, this provision is taken from which constitution, or sometimes they will ask parliamentary system from where, fundamental rights from where, independent judiciary from where. So you must be thorough with the provisions we have borrowed from the constitution of other countries. Next is American Constitution, that we shall discuss in the next class.